there was a congressional action to permit Confederate officers or people who supported the Confederacy to hold office before the 14th Amendment, correct? So there must have been a thought that there was a pre-existing disqualification.
That's absolutely right. There were a flood of amnesty requests even before Section 3 went into effect because everybody understood at the time that those people would be disqualified the moment that Section 3 was enacted forever unless they received amnesty.
Counselor, what do you do with what would seem to me to be plain consequences of your position? If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason—
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong. And maybe they thought it was right. And we'd have to develop rules for what constitutes an insurrection.
Yes, Your Honor, just like this Court interprets other constitutional provisions, this Court can make clear that an insurrection against the Constitution is something extraordinary. And in particular, it really requires a concerted group effort to resist through violence, not some ordinary application of state or federal law, but the functions mandated by the Constitution
On your point
itself.
that it's been